Eyeballs. Okay, so seeing that we have a quorum, I'm going to call to order this meeting of the Board of Adjustment for the 26th of May. Do I have a motion to accept the agenda?
So do.
Second.
All in favor, say aye.
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 Motion to accept the minutes of the last meeting?
So move.
Second.
You guys are going to be busy here.
Yep.
All in favor, say aye.
Aye.
Approved. Motion to accept the public notice. That word would come to me eventually. Pardon? Has it been public until he noticed? Yes. Okay. I'll move that we accept the notification of the public.
Second.
All in favor?
Aye.
Aye.
It's really lonely up here, I gotta tell ya. Okay, so I'm Linda White, this is Dave Allen, and
Robin Meyer.
Jeff, you know I'm having a burp this morning, right? All right, so we're your board members for today. 3 of us make a quorum, so we can make decisions, or we can postpone decisions if we don't feel we have enough information. I don't know how to proceed with these because they're both old cases. So do we read the thing into the record like we would otherwise?
You're simply just introducing the item.
Yeah, so just read the agenda item.
Yeah, just read the agenda.
And proceed.
Okay, hopefully I downloaded the agenda. Oh, paper one. Oh, wow, she's helping me cheat today. Oh, that's great. Okay, so the agenda item, the first one is a discussion and possible action on a decision from SP 0322, Emily Hendricks appeal. This appeal pertains to the petition considering a special exception permit pursuant to 9.036, Section 5 of the Sauk County zoning ordinance for approval of operating a lodging house. The appeal is associated with land as described in Lot 1, Lake Redstone, Owl Addition, in part of the northeast quarter of the northwest quarter of Section 13, Township North 13, North, Range 3 East, Laval. Tax parcel number 024-2224-00-000. Okay, so in this one, they applied for a lodging house permit. They did not have all of the information for Laval for their application, and we wanted to make sure that the township had its say. So you may come up. Please raise your right hand. I still don't trust you.
That's okay.
You sort of tell the truth to the best of your knowledge.
I do.
All right, name?
Will Christensen, LRE staff. So I'll just provide a brief overview. I don't plan on reading the whole public or the whole staff report again, which was read at the last public hearing and is available on Granicus again with all of the exhibits, including Exhibit H, which was the public comments mailed and emailed for the public hearing on the appeal. The public hearing portion of the appeal was closed on the February 24th meeting date, as you just suggested. The town of Laval's recommendation was to postpone, and as you also mentioned, the BOA voted to postpone the decision until this hearing date. I have provided additional exhibits, which is information that has been provided since the February hearing. Exhibit I is the Laval Town Board meeting minutes from March 14th. Item 13 on page 3 is the recommendation from the town of Laval, which I will read. Motion by Damaski, second by Rigo, to recommend to Sauk County Land Resource and Environment Department to support and approve the county special exception permit and land use permit, and the board approves the short-term rental permit for Emily Hendricks, has met the requirements, and to make the request to have a letter sent to Emily Hendricks asking if the property lines could be marked on the ground with a stake if the other property owners agree, and mark on the ground for the easement access to the lake. And to post the address of the rental on the easement access to the lake, and to post the address of the rental on the wall and in the house rules. And it was a 4-1 motion carry. Exhibit J is the health department license, which is a requirement of the special exception, or a condition of the special exception permit, or recommended condition. Exhibit K is additional information from the applicant, and she provided a cover letter. I will read that. To whom it may concern, after reviewing the Sauk County BOA meeting minutes from February 26, as well as the Town of LaValle meeting minutes from March 14th, the only conditions noted to address were marking the property boundary and adding the property address to the house rules. I did receive support and approval from the Town of LaValle, and have also completed the DATCAP, or State Health Department license. Included in this document are pictures showing the property boundary and markings for E4689 Winnebago Court, Laval. The property boundary has been marked with stakes and lights to clearly define the property boundaries. Since the Sauk County BOA meeting on February 26, 2022, I have received messages and support from Lake Redstone residents and property owners. I would also like to note that I have had 6 property owners inquire about their extended family renting the property this summer and while visiting the area. I believe I have met the requirements of Wisconsin state law and will agree to any and all conditions the county believes are necessary. Respectfully, Emily Hendricks. So the staff recommendation, based on the information provided and analysis of section 7.152, parent 5 and parent 6, and 7.083 of the Sauk County zoning ordinance, staff submits that the application meets the standards and requirements for a special exception permit to be approved, and the department recommends approval of this application with the recommended conditions listed in the staff report and provided at the last public hearing.
Okay, so the things that we're supposed to consider with this is whether it's going to change the character of the neighborhood?
That is one of the requirements,
Yeah.
yep.
Why don't you read the requirements that we're supposed to look at into the record, so I don't have to read the whole thing? Those are in the staff report.
Yep. In reviewing the special exception, the Board of Adjustment shall follow these standards. The establishment, maintenance, or operation of the proposed use may not be detrimental to or endanger public health, safety, or general welfare of the occupants of surrounding lands. And the use shall be designed, constructed, operated, and maintained so as to be compatible and appropriate in appearance with the existing or intended character of the general vicinity, and that such use may not change the essential character of the area by substantially impairing or diminishing the use, value, or enjoyment of existing or future permitted uses in the area. I think those were the main 2 that we're concerned with.
Okay. Questions? Okay, thank you, sir.
Okay.
All right, so we're going to go into deliberation. I have real concerns about this one, like I did last time, as being something is detrimental to the neighborhood as far as changing the character of it. I'm very concerned that they have 11 o'clock as quiet hours. You're in a family community where a lot of people come with their families, and 11 o'clock is the latest we've ever seen on a permit come through. Dave?
Well, I was just gonna say, now it has the township's approval, blessing, and not land conservation, but the recommendation from them. And I guess, I know there was a lot of controversy from the residents that live in that neighborhood, and I appreciate that. But our safety net is if things aren't being done right, we can revoke the permit. So there's really not a lot of risk there.
Okay.
I would agree that one of the reasons I agreed to postpone or voted for that was to give the town time to provide their input. It appears with a 4-to-1 vote that they are supporting it. The quiet hours, I think, let's see how that works out. As David mentioned, there's always the opportunity to pull a permit, but I think she's met the statutory guidelines of having short-term rental or lodging house, and I don't see anything that would prevent approval.
Okay. I will move that we approve this with a change in their mandatory hours of quiet time at 10 o'clock, as out of respect for the rest of the neighbors that are around there, and with the conditions and terms placed by the Sauk County Zoning Board
And the town.
and the town.
I would second that.
All in favor, say aye.
Aye.
Opposed? Only changes, you have to be quiet at 10 o'clock. Okay, next.
You want to read the next agenda item? Linda?
Oh, excuse me. Next agenda, excuse me. All right, discussion and possible action on the decision for SP 722, the Knutson appeal. The appeal pertains to the interpretation of Sauk County Ordinance S 8006, paragraph 2, and S 8006 4C3. The appeal is associated with land described as Lot 20, plat of Beau Ravine North, in the tax parcel 032-1045-00000, town of Spring Green, Sauk County, Wisconsin, and owned by Andy Knutson.
Did you receive anything from the attorney that represented us?
I talked to him, and he drafted basically 4 possible answers, so that we could, if you said yes to both, no to both, yes to one and no to the other, so that we would have something to look at when we came here today.
Do we have copies?
Did he send that to the office, or did he just send it to me? Okay, look. Oh, shoot. See if I can get this to forward. I don't know if I actually hooked up to this computer system. All right, do you have a way that you can get into my email account, and I can forward that to the office to be printed?
Can you get into it? We can't access your email. Can you access your
Can I
email
eat-
and send it to one of us?
Right, but can I access my email on one of your computers to send it to you? Because I'm not connected to the system here. My computer isn't bringing up the system, so I can open my email to get those downloaded.
You're not on the internet here?
I download everything at home, and that came in late last night, and I didn't think to download it. Unless somebody knows.
Which email did he send it to, Linda? Do you just need to connect to the internet?
Yeah, linda@krdairy.com.
Okay,
There, here's the one.
go to your wireless settings.
See the Sauk County Gas?
And then type it in exactly as you see it here.
Okay, capital letters.
Yep, all caps.
You guys are so smart in how you put that in. Yes.
You're connected, so you should be able to get into it now. If you just hit refresh up there, the little circle, it should load it.
Oh, that
There
was
you
so
go.
simple. You make it easy.
Linda, if you just want to send that to my email, I'll print it up if that works.
Okay. Brian, what's your email?
Should come brian.simmer@saukcounty.gov.
SIMMER?
T.
T, 2 R's? SIMMER. Okay.
Figured it would come up because of other emails.
And,
Sauk County.
Yeah, no, you didn't come up on this one. Wait a second. Oh, there you are. Go see, two of the attachments are on there, that if you could print those off. So the discussion is, when we talked to him last, we had said in closed session that we thought that the county had interpreted things correctly on both. I'm still convinced that they interpreted it correctly on the second one, as far as building that road into the wetlands. I'm just not sure who's supposed to have the responsibility for figuring out what the discrepancy is, whether the county is supposed to be going after that determination or whether the individual is, because I couldn't find anything that said specifically. In the DNR code, we were required to do it, and that was written right into the code. But there isn't anything that specifically says, here's how we're gonna, who has to prove what.
Excuse me, Linda,
Oh.
you sent the email without the attachments.
Why did it do that? All right. Oh, I guess I probably should have forwarded it instead of just sending. Thank you, Ryan. We'll get there eventually. Okay, should arrive now?
Might take a moment.
Okay.
So there was two issues, correct? There was a retaining wall,
There was two issues, and one was the location of the retaining wall, whether it was in or outside of the wetlands, because one thing that they turned in said it was in the wetlands, and the other one said it was 6 feet from it,
who's we turned it in?
the applicant.
Oh, okay.
All right, and so the question is, who is responsible for finding out whether that's true or not? The other issue that's gonna come up with that is that they're supposed to, when you're in the wetlands like that, you're supposed to only build on the foundation of what was there. You're not supposed to alter it. And they changed it, changed the shape of the wall. So the wall wouldn't qualify for a permit that way. They had no permits for either of them. Most of the stuff could have been resolved if they had come in for permits first, before they ever did this stuff. On the second one, they would have had to go to the DNR for a plan, and then they would have had to come to us for a filling and grading plan if they had something that was permitted by the DNR. And in 24 years of experience, I have never seen the DNR permit something like this. And so I don't believe that they're reading it correctly. I believe the office has read it correctly, and that they need to go to the DNR and work it out with them.
Yeah, I am.
But I'm a little torn on the other one as to who has to determine whether it's in a wetland. It's gonna be a problem no matter what, because he didn't build on the foundation. So whether he determines it or whether they determine it, even if it's not within the wetlands, it's within the wetland district, and so he's still gonna be in trouble for it.
And the trail is definitely in a wetland.
Yes, absolutely. Absolutely. The DNR would, yeah, I can't imagine them having approved that when you could put a boardwalk in, they've been fine with, because you wouldn't have disturbed anything underneath. Okay. What you've done disturbs the flow in there. It's okay. It's not us you have to approve that to. You have to get your permits from the DNR for having that there. Pardon?
Linda, he needs to come up to the microphone if he's gonna talk, so it's on the record.
Okay, we'll turn this into public hearing part. Come on up, sir.
We did
Nope.
not notice this as a public hearing.
Oh, we didn't notice it as a public hearing.
You can ask him questions.
All right.
The applicant
Well, his
chooses.
opinion may be
Otherwise,
different than
just
mine is.
Making a decision.
Yeah, his opinion may be different than mine is. Your opinion may be different than mine is.
Yeah, I'd like to see the stuff from the attorney before we proceed.
Yeah. was making signs up for a yard sale, so I was literally waiting for paint to dry. And that's what this feels like, waiting for paint to dry.
Yep.
So the estate sale starts tomorrow, Dave, if you need more pots and pans or trinkets or
Oh,
garden
for Christ's
stuff.
sakes, I don't know how I'm gonna have to tie my wife up. She just keeps bringing stuff home.
Uh-huh. Jerry's first comment was, "It's not coming here, is it?"
And I always say to her, why don't you have a garage sale? Well, who would buy that stuff?
She would.
I said, you did.
Oh, that's
Good,
funny.
yeah. We have so much cupboard space. When we remodeled our kitchen, I put the cupboards all the way to the
I
ceiling.
remember you mentioning that.
And, you know, you put things there you don't use,
Mm-hmm.
and everything's still full.
And, yeah, and they can still be there, but they're just out of sight. Thank you.
So I'm handing these out separately, they look the
Yes.
same, but they are different.
No, they are different. That's correct.
That's number 2.
This is number 1.
That's number 1, here's number 2.
Brian, the lawyer has advised that either one of these that are chosen should be read into the record.
Okay.
Are you ready to read? I'm going to nominate one of you to read it off.
I mean, I can, sure.
Okay. Thoughts?
In reading the attorney's recommendations,
Well, that's his summary based on the testimony that was here, so it's not him just doing the decision, it was taking it from our information,
correct.
just for clarity.
The item we're looking at here is really whether or not the requirement of the wetlands delineation is needed, correct?
No, it's whether he's responsible for it or whether the office is responsible for it. Because they have said he needs to do it and put that in with his permits. And he and his lawyer say, well, there's nothing that says we have to do that. You're looking at the second page, number 5, under responsibility for wetland delineation.
Mhm.
I wouldn't think anything could be done without the DNR's approval.
Right, that's a side thing. Did the county make the appropriate decision in not issuing him permits or applications for permits to get a hindsight permit on this wall. They said, you can't do it because we don't know where the wetlands are. And he said, I shouldn't have to delineate that. And they said, that needs to be part of your application, because it's not only the wetlands that's on the map, it's any wetlands that are obviously near it. And everything else we do, when there's a toss-up, government always wins.
That was what I was
Yep.
thinking.
So I'm gonna move that we support the office on both of these measures. And, you have to get permits, and you have to get permits by the rules that they've said you have to get permits by. And, on the second one, I don't agree with your reading of the ordinance for, access into there. You can discuss it with the DNR. If you can convince them that this is fine and get them to sign off it, I welcome you to come back and apply for a permit. But I don't think you read it right, and I think they're going to say you didn't read it right either. So, second to that motion?
I would second your motion, Linda.
All in favor, say aye.
Aye.
Okay. So we support the office in this. You have a copy of the paperwork, correct? All right. So we shouldn't have to read it into the record then if he has a copy of it already. I don't think. Everybody's looking at me.
It's an exhibit, just like another exhibit would be one, and as long as
That's
it's
true.
made part of
That's true.
the
And
record,
he does have a copy of it, so he can go right to the office and talk to them about it if he needs to.
it's a decision letter, so.
Yeah,
Yeah, Linda, why don't we just read it into the
Okay.
record so we're covered?
yeah, just in
Okay.
case.
Am I volunteering to do that?
Yeah, go for it.
Notice how I delegated that out. Wasn't that nice?
All right,
All right.
So I'm just going to read the whole decision letter to make sure we're covered on all fronts, if
Sure.
that works. So the decision letter, which is dated today, it says, Dear Mr. Knudsen and Ms. Bailey, on April 28th, 2022, the Sauk County Board of Adjustment considered an application for an appeal pursuant to Section 8.01, 8 sub 4 sub B of the Sauk County Shoreline Protection Ordinance, in which it is alleged that there was an error in the interpretation, order, requirement, decision, or determination made by the zoning and administrator in the enforcement, administration, or interpretation of the Sauk County Code of Ordinances, sections 8.006 and 8.006 sub 4 sub C 3. The appeal is associated with land described as Lot 20, plat of Bow River Lane North, including tax parcel 032-1045-00000, Town of Spring Green, Sauk County, Wisconsin, and owned by Andrew Knudsen. Based upon the applicable records, evidence, and testimony presented at the hearing, the Board of Adjustment has denied the appeal and affirmed the decision of the administrative official. The decision is based on the following findings of fact. Number 1, Andrew Knudsen and Heidi Bailey own property located at South 13074 High Banks Road, Town of Spring Green, Sauk County, tax parcel 032-1045-0000, referred to as the property. Number 2, the owners of the property constructed a new retaining wall, constructed a path, and placed fill in the property without obtaining required permits from Sauk County. Number 3, in September of 2021, the Wisconsin Department of Natural Resources notified staff, county staff, of potential violations at the property relating to these projects. County staff evaluated these potential violations and engaged with the owners on multiple occasions thereafter. Number 4, county staff informed the owners, and the owners must have a wetlands delineation conducted on the property before a permit application for an after-the-fact approval of a retaining wall and path could be processed. The owners were also informed that where it is determined that wetlands are present in the same location as the path or retaining wall, those areas must be rezoned from the Shoreline Wetland Zoning District, or these structures or portions thereof must be removed. These determinations are the subject of this appeal. Number 5, on March 8th, 2022, an appeal of the county staff decision was filed with Sauk County on behalf of Andrew Knudsen. Number 6, on April 6th, 2022, a hearing on this appeal was held before the Sauk County Board of Adjustment. Number 7, based on field observations conducted by county staff, wetlands could have been and may still be present in the location of the retaining wall and nearby portions of the path. Number 8, because the owners did not apply for necessary permits prior to undertaking these construction projects, and county staff therefore did not conduct a pre-construction site visit, it is impossible to readily verify post-construction if the retaining wall and nearby portions of the path were constructed in wetlands unless a wetland delineation is conducted on the project site. Number 9, county staff cannot render a decision on the post-construction after the fact permit application for the retaining wall and nearby portions of the path until the location of wetlands at or near the project site are determined, requiring an official wetlands delineation. Number 10, the retaining wall and path are used by the owners and no one else by right for private purposes. Conclusions of law. The Sauk County Board of Adjustment has the authority pursuant to Sauk County Code Section 8.018 Sub 4 Sub B to hear and decide appeals where it is alleged there is an error in any interpretation, order, requirement, decision, or determination made by an administrative official in the enforcement, administration, or interpretation of the Shoreline Protection Code. Based upon the above findings, information provided at the public hearing, and review by council, the Board of Adjustment concludes scope of Sauk County Shoreline Wetland Zoning District. Number 1, Sauk County Code Section 8.006 Sub 1 provides that the Shoreline Wetland Zoning District shall include all shorelands within the jurisdiction of this ordinance which are designated as wetlands on the most recent version of the Wisconsin Wetland Inventory, as depicted on the DNR Surface Data Viewer, the DNR maps. And those wetlands defined in Section 8.004 of this ordinance shall be included in the Shoreline Wetland District. Sub 2, or number 2, Sauk County Code of Ordinances, Section 8.004 defines wetlands as those areas where water is at or near or above the land surface long enough to be capable of supporting aquatic, hydrophytic vegetation and have soils indicative of wet conditions. Number 3, therefore, Sauk County Code of Ordinance, Section 8.006 Sub 1 specifically includes within the Shoreline Wetland Zoning District both wetlands depicted in DNR maps and other wetlands that meet the definition under Sauk County Code Section 8.004. Projects in DNR map wetland areas and in areas where other unmapped wetlands exist are both subject to the restrictions of the Shoreline Wetland Zoning District. Number 4, modifications to the DNR maps need to be made prior to the application of Shoreline Wetland Zoning District requirements and restrictions in wetlands that are not depicted on the DNR maps. Responsibility for wetland delineation. Number 5, Sauk County Code of Ordinances Sections 8.006 Sub 2 and 8.007 provide the procedure to be used where there is an apparent discrepancy between the Shoreline Wetland Zoning District boundary shown on DNR maps and the actual field conditions. In such circumstances, the county shall contact the DNR, and if the DNR determines that the DNR maps are in error, the county may make its permitting decisions in accordance with the DNR's determination, and a process for modifying the DNR maps is provided. Number 6, pursuant to conclusion of law number 3 above, the presence of an apparent or determined discrepancy between the DNR maps and actual field conditions does not allow a property owner to take action inconsistent with the requirements and restrictions of the Shoreline Wetland Zoning District in actual wetlands not designated as wetlands on the DNR maps. Number 7, given the uncertainty regarding the location of wetlands in and around the project site, county staff were correct not to proceed with processing the post-construction after the fact land use permit application for the retaining wall in nearby portions of the path without information regarding the location of wetlands at or near the project site. This background information is necessary to process such an application based on field observations conducted by county staff. Number 8, the Sauk County Board of Adjustment concurs with county staff's conclusion that the owners must complete a wetlands delineation of the project area, including the areas in which the retaining wall and path are constructed, and provide that information to county staff prior to processing of a post-construction after the fact land use permit for the project. Number 9, nothing in the Sauk County Code of Ordinances, including provisions relating to the process for amending the DNR maps as noted in conclusion of law number 5 above, imposes upon the county or the DNR the responsibility to conduct a wetlands delineation for project sites. Number 10, the presence or absence of wetlands on a project site is a determinative factor in land use permit appeal eligibility, where county staff have reason to believe, as they did here, that wetlands may be present at or near the project site. It is within their responsible discretion to require an applicant to conduct a field evaluation of the actual location of the wetlands to generate the information necessary to proceed with the project review. Number 11, should a delineation of wetlands on the project site identify discrepancies in the boundary of the wetlands as shown on the DNR maps, county staff will be required to follow the procedures in Sauk County Code sections 8.006 sub 2 and 8.007 to seek amendment to the DNR maps. Allowable uses and filling activities in the Shoreland Wetland District. Number 12, Sauk County Code of Ordinances section 8.006 sub 4 and 6 specify uses that are allowed for property in the Shoreland Wetland Zoning District. Sauk County Code section 8.006 sub 4 provides a list of permitted uses that are allowed subject to compliance with other applicable laws. Number 13, as relevant to this appeal, Sauk County Code section 8.006 sub 4 sub C provides a list of permitted uses in the Shoreland Wetland Zoning District. Sauk County Code section 8.006 sub 4 sub C3 lists a private recreation area as a permitted use in the Shoreland Wetland District. Number 14, the path at issue in this appeal does not qualify as a private recreation under Sauk County Code of Ordinances. Private recreation is defined in Sauk County Code section 8.004 as facilities, structures, buildings, or property which are privately held that require a fee, membership, or residence for use or participation. This definition clearly contemplates that for a use to qualify as a private recreation area, it must involve more than one property owner using his or her property for private recreational purposes, as is the case here. Number 15, the use of the path does not require a fee, membership, or residence for use or participation as the term is intended under Sauk County Code section 8.004. Number 16, if conclusions of law number 14 and 15 were incorrect, any part of any private property could be classified as a private recreation area, thus allowing the construction of facilities, structures, and buildings without limit in the wetlands in the county. This is an impermissibility absurd reading of the ordinance. It is clearly inconsistent with the purposes of the Shoreland Wetland Zoning District in Sauk County Code section 8.006 sub 3 to control building and development in wetlands whenever possible, and is inconsistent with and prohibited by state law under Wisconsin Administrative Code section NR 115.04. Number 17, no other provisions of the Sauk County Code authorizes the construction of a path of the type installed by the owners in the Shoreland Wetland Zoning District. Number 18, even if the path qualified as a private recreation area, Sauk County Code section 8.006 sub 4 sub C provides that filling associated with any permitted uses under that paragraph is only allowed to the extent specifically provided in the code paragraph. There is no provision in the code authorizing filling for a private recreation area. In the subparagraph listing a private recreation area as a permitted use, the only allowable filling activity contemplated is filling necessary for the construction or maintenance of a public boat launching ramps or attendant access roads, not filling related to private recreation areas. The construction of the path at issue in this appeal involved the placement of fill in and the act of filling the path area with gravel, breaker rock, and or similar materials. Because the construction of the path involved filling that is not permitted under Sauk County Code, it is prohibited. Number 19, the construction of the path of the type constructed by the owners in the Shoreland Wetland Zoning District is prohibited. For a land use permit to be approved for such a path, the location of the path must be rezoned to remove it from the Shoreland Wetland Zoning District. The process for such a rezone is specified in Sauk County Code section 8.007. Decision of the Board of Adjustment. The Sauk County Board of Adjustment hereby affirms the determinations made by the administrative official and denies the appeal. Notice of appeal rights. You have the right to appeal the determination of the Board of Adjustment by commencing an action seeking the remedy available, I don't know how to say that word, thank you. Any action to appeal the determination must be filed with the Sauk County Circuit Court within 30 days of the filing of this decision. Yours very truly, Sauk County Board of Adjustment, Linda Whiteshare.
Okay. All right, with that, is there any other business? No? Do I hear a motion to adjourn?
I would move to
You're
adjourn.
always quick.
Second.
All in favor?
Aye.
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 Okay.